Florida probate lawyer suspended by the Florida Supreme Court from practicing law for 1 year. Hello, my name is John P.L.C. I'm going to be speaking to you today about a disciplinary ruling issued by the Florida Supreme Court regarding a Palm Beach County probate lawyer and what he did wrong and why he's been suspended from the practice of law for 1 year. So Florida probate attorneys or personal injury attorneys who are involved in wrongful death cases and who may need to open up a Florida probate will probably want to read the judgment of the Florida Supreme Court and learn a little bit more about the facts and circumstances around this sad case. My name is John P.L.C. I'm a probate litigator in West Palm Beach, Florida with the P.L.C. law firm. We handle trials, disputes, and appeals regarding wills, trusts, estates, guardianships, as well as related business and commercial litigation. So the case that I'm speaking to is the Florida Bar versus Kevin Kenneth Boyles, B-O-Y-L-E-S. The case number is SC Supreme Court 15, 2015, 192. This was an uncontested report of a referee that was assigned to investigate Mr. Boyles. And on Thursday, March 24th, 2016, the Florida Supreme Court issued its judgment. It's a 2-page judgment. It's signed by the clerk. It has accepted the uncontested report of the referee and suspended this Florida probate attorney from practicing law for 1 year. Judgment was entered in that decision. So exactly what happened and what went wrong. And this is where the worlds of probate and wrongful death collide in Florida, or at least overlap. Evidently, the defendant or the respondent, who was a Florida probate and Florida estate attorney in Palm Beach, went to the Department of Motor Vehicles and requested data or information about accidents or crashes that involved a fatality. After he received that information, he filed petitions for administration in various counties to open up a probate or to open up and begin a Florida estate administration proceeding. In 12 matters, he requested to be appointed the personal representative of the estate or the executor of the estate. He alleged that he was an interested person under the Florida Probate Code, and in 15 matters, he evidently filed wrongful death lawsuits. Evidently, he had no communications or little communications with the decedent survivors, and evidently he had no authority from them prior to filing these matters. So the Florida Supreme Court was a little disturbed by this lawyer, this probate attorney in Florida, requesting information from the Department of Motor Vehicles, and then opening up estates, and then not having any prior communications with family members or any of the decedent survivors. Many times Florida probate attorneys are asked to participate in wrongful death cases by personal injury attorneys because you need to file a wrongful death action in the name of the personal representative, in the name of the estate as the plaintiff, and you have to open up a probate. In addition to that, the division of any settlement monies or any judgments or any verdicts, any monetary damages are supposed to be divided up among the survivors or the heirs under the wrongful death statute. And this can often be done in the probate court. Sometimes it can be done in the civil action, the wrongful death action. This concludes my remarks about Florida probate litigation and a recent disciplinary proceeding against the Florida estate lawyer.